on how things shake out, do you think that all of the Obama-era NLRB decisions are now in jeopardy?
I think the ones that Matt and Jared touched on, I think those are the ones that have caused the most amount of discussion and are most likely to get reviewed, and whether they actually will fall or change is a whole other decision. I mean, for example, one case I talked about was King Supers. You know, if that case continues, for example, or if it goes to another appellate level and they say, well, look, this is going to be the standard for damages, well, there really isn't anything else that the board can do about it. The court said this is how it's going to go, and I think both those guys talked about various court cases as well. So I think we have to kind of see where it's going to shake out, but I forgot what one of the co-presenters was saying. I think it takes some time, and we have to see, but some will likely at least be looked at more seriously than others.
I think along those lines, I think, Kate, the decisions relative to whether or not arbitration clauses prohibiting in contracts or employment contracts prohibiting class action outside of arbitration, there's right now a circuit split on whether or not those are legal or not. If that gets taken up by the Supreme Court before the NLRB addresses it, then I think that, you know, that's one thing that may or may not last. So the timing is pretty much everything in a lot of times. So that's an issue that may last or may not.
And the one point I would add to all of that is unlike precedents in the circuit, board precedent seems to carry little weight, and the board, at least in recent years, has not hesitated to reverse precedent or clarify precedent in a way that reverses it. So it's not out of the ordinary for the board to just completely change some of these Obama decisions, and I think there are a lot of them that are vulnerable.